Fisher v. United States, Supreme Court, 1976. Justice White delivered the opinion of the court. In these two cases, we are called upon to decide whether a summons directing an attorney to produce delivered to him by his client in connection with the attorney-client relationship is enforceable over claims that the documents were constitutionally immune from summons in the hands of the client and retained that immunity in the hands of the attorney. 1. In each case, an Internal Revenue agent visited the taxpayer or taxpayers and interviewed them in connection with an investigation of possible civil or criminal liability under the federal income tax laws. Shortly after the interviews, the taxpayers obtained from their respective accountants certain documents related to the preparation by the accountants of their tax returns. Shortly after obtaining the documents, the taxpayers transferred the documents to their lawyers, Respondent Cashmere and Petitioner Fisher, respectively, each of whom was retained to assist the taxpayer in connection with the investigation. Upon learning the whereabouts of the documents, the IRS served summonses on the attorneys, directing them to produce documents listed therein. In each case, the summons was enforced by the district court, and its order was stayed pending appeal. In our view, the documents were not privileged either in the hands of the lawyers or of their clients. 2. All of the parties in these cases have concurred in the proposition that if the Fifth Amendment would have excused a taxpayer from turning over the accountant's papers had he possessed them, the attorney to whom they are delivered for the purpose of obtaining legal advice should also be immune from subpoena. Although we agree with this proposition, we are convinced that it is not the taxpayer's Fifth Amendment privilege that would excuse the attorney from production. The taxpayer's privilege under this amendment is not violated by enforcement of the summonses involving in these cases because enforcement against the taxpayer's lawyer would not compel the taxpayer to do anything and certainly would not compel him to be a witness against himself. The court has held repeatedly that the Fifth Amendment is limited to prohibiting the use of physical or moral compulsion exerted on the person asserting the privilege. In Couch v. United States in 1973, we recently ruled that the Fifth Amendment rights of a taxpayer were not violated by the enforcement of a documentary summons directed to her accountant and requiring production of the taxpayer's own records in the possession of the accountant. We did so on the ground that in such a case, the ingredient of personal compulsion against an accused is lacking. Here, the taxpayers are compelled to do no more than was the taxpayer in Couch. The taxpayer's Fifth Amendment privilege is therefore not violated by enforcement of the summonses directed toward their attorneys. This is true whether or not the amendment would have barred a subpoena directing the taxpayer to produce the documents while they were in his hands. The fact that the attorneys are agents of the taxpayers does not change this result. Couch held as much, since the accountant there was also the taxpayer's agent, and in this respect reflected a long-standing view. Nor is this one of those situations where constructive possession is so clear or relinquishment of possession so temporary and insignificant as to leave the personal compulsion upon the taxpayer substantially intact. It is argued that if the summons was enforced, the taxpayer's Fifth Amendment privilege would be, but should not be, lost solely because they gave their documents to their lawyers in order to obtain legal advice. But this misconceives the nature of the constitutional privilege. The amendment protects a person from being compelled to be a witness against himself. Here, the taxpayers retained any privilege they ever had not to be compelled to testify against themselves and not to be compelled themselves to produce private papers in their possession. This personal privilege was in no way decreased by the transfer. It is simply that, by reason of transfer of the documents to the attorneys, those papers may be subpoenaed without compulsion on the taxpayer. The protection of the Fifth Amendment is therefore not available. The proposition that the Fifth Amendment protects private information obtained without compelling self-incriminating testimony is contrary to the clear statements of this court that under appropriate safeguards, private evidence, if they are not compelled at the time that they are uttered, and that, something's weird, safeguard. Proposition that the Fifth Amendment protects private information obtained without compelling self-incriminating testimony is contrary to the clear statements of this court that under appropriate safeguards, private incriminating statements of an accused may be overheard and used in evidence if they are not compelled at the time that they are uttered, and that disclosure of private information may be compelled if immunity removes the risk of incrimination. If the Fifth Amendment protects generally against the obtaining of private information from a man's mouth or pen or house, its protections would presumably not be lifted by probable cause in a warrant or by immunity. The privacy invasion is not mitigated by immunity, and the Fifth Amendment's strictures, unlike the Fourth's, are not removed by showing reasonableness. First Amendment values are also plainly not implicated in these cases.